Imagine waking up on a Monday morning, you're just lying in your own bed in your own apartment.
Right.
You're in your underwear, just totally relaxed. And suddenly you hear that distinct metallic click of a key turning in your front door.
Oh, that is just the worst feeling. Total panic.
Exactly.
Yeah.
Before you can even process what is happening, the door opens, and your landlady casually walks right into your bedroom.
Just right in.
Right in. And she's accompanied by some utility worker you barely even recognize. And when you ask, what are you doing in my apartment?
Yeah, like, what's the excuse?
She just waves a hand and says, oh, we just forgot to check the water meter on Friday.
Wow. I mean, the sense of violation in a moment like that is just, it's profound.
It really is. It's the kind of scenario where a person's immediate instinct is to seek some kind of aggressive retaliation.
Oh, for sure. You want a lawyer who will just act as an attack dog.
Exactly. But what we're looking at today in this deep dive, it challenges that entire assumption, like how we seek legal counsel in moments of extreme vulnerability.
Yeah, because the counterintuitive reality we are exploring today is that a cluster of artificial intelligence models might actually be better equipped to handle this emotionally volatile situation than a traditional human attorney.
Which is wild to think about.
It is. And that brings us to a highly unusual and completely fascinating piece of source material.
Yeah, tell us about the transcript.
So we have this transcript dated May 2026, and it's documenting a real-world experiment. A tenant experienced that exact Monday morning intrusion we just talked about.
Right.
But instead of, paying a massive retainer to a tenancy lawyer, they took their case to a literal gauntlet of AI models.
A whole gauntlet of them.
Yeah. We are looking at a simultaneous consultation involving Gemini, various iterations of ChatGPT, Claude, Mistral, and even a specialized legal AI persona called Viera.
That is a lot of processing power for one landlord dispute.
Seriously. And the mission for our deep dive today is to analyze this modern experiment in AI crowdsourced legal counseling.
All right, so we're going to deconstruct this whole landlord-tenant dispute, examine how different AI architectures interpret the highly rigid structures of German rental law, right?
Exactly. And we'll get to observe in real time as an AI is coaxed into drafting an increasingly aggressive legal settlement.
It's so fascinating. And, whether you rent an apartment, own property, or just have a passing interest in how artificial intelligence navigates complex human conflicts, this case study is an absolute masterclass.
It really is. It reveals the underlying mechanics of negotiation, the strategic application of leverage, and the cold reality of the law versus what a person feels they morally deserve.
Okay, let's unpack this.
So we have to establish the timeline of the intrusion first before we can really dissect the legal advice.
Right, the context matter.
Yeah. The sequence of events is critical to how the AI models formulate their strategies. The tenant lays this out minute by minute in their prompt.
Okay, lay on us.
The inciting incident begins on a Thursday morning, May 4th, 2023. At exactly 7:58 a.m., the landlady sends an email stating that the power company needs to check the electricity meter the following day, Friday, at 11:00 a.m.
Okay, pretty short notice, but okay.
But she includes this caveat. She writes, if you aren't there, I can use my key to do this with the representative. Please answer.
Oh, wow. Okay, so right off the bat, she's threatening to use her key.
Exactly.
Now, the tenant works from home as a freelancer, a fact the landlady is completely aware of. He sees the email, but doesn't reply in writing.
Right, he just ignores the email itself.
Yeah, but he is simply present at the apartment on Friday at 11:00 a.m. He opens the door, lets the landlady and the utility worker inside. They check the electricity meter, and the appointment concludes without any issues.
So crisis averted, basically.
Right. The boundary-pushing nature of that Thursday email, the casual threat to use the key, it's somewhat neutralized because the tenant is present to facilitate the entry.
But the real complication arises Friday evening. At exactly 17:22 p.m., so 5:22 in the afternoon, the landlady sends a second email.
End of the work week.
Right. End of the day on Friday. She states they need to return to the apartment on Monday around 11:00 a.m. to read the water meter.
Okay.
And she ends the email with, are you there? I ask for an answer.
See, the tenant unplugs for the weekend, which is a totally standard boundary for a freelancer.
Yeah.
You don't check work emails on Saturday.
Exactly. You need that time off.
So he does not read the Friday evening email. He has absolutely no idea the landlady plans to return.
Which sets up the Monday morning intrusion we discussed at the start of the deep dive.
Right. Lying in bed in his underwear.
Yep. The landlady and the utility worker use a key to bypass the locked door and just enter the bedroom while the tenant is undressed.
And when he confronts her, she just offers that excuse
Yeah.
that they simply forgot to handle the water meter on Friday.
It's just wild. The audacity of the excuse treats a bureaucratic oversight as a valid license to bypass fundamental privacy rights.
It really does. Now, to understand the legal mechanics of why this is such a severe violation, we need to analyze the contractual nature of the key she used.
This is a huge point. In the prompt provided to the AI gauntlet, the tenant explicitly notes that the spare key held by the landlady was designated exclusively as an emergency key.
I see this point of contention constantly in property disputes, The legal definition of an emergency in German rental law is incredibly strict.
Very strict. It's not just, oh, I forgot to read the meter.
No. An emergency key is retained for catastrophic imminent threats to the physical structure of the building. We are talking about a burst pipe rapidly flooding the floorboards, or a literal fire.
Right. It is a protective measure for the property, not a convenience tool for administrative tasks.
Exactly. It's like giving your neighbor a spare key to feed your cat while you're out of town, and they use it to come over and watch your television while you're sleeping because their own TV is broken.
That is a perfect analogy. The authorization was granted for a highly specific conditional function.
And the AI models, they reach an immediate consensus on this point, don't they?
They do. Water meter reading is a scheduled administrative requirement. It totally lacks the element of imminent destruction required to trigger emergency access protocols.
Right.
So the landlady possessed zero contractual authority to use that key on a Monday morning.
But let's look at the concept of implied consent for a second, because landlords frequently operate under a really flawed assumption regarding communication.
Oh, big time.
Like the landlady sent an email late Friday afternoon. The tenant did not reply. A common argument from landlords in these situations is that silence, following a notice of entry, constitutes tacit approval.
Yeah, they operate under the logic of, well, I informed you of my intent, and by not objecting, you consented.
But does the tenant's silence over the weekend equal consent? I mean, how do the AIs view that?
The AIs dismantle that assumption with unified clarity. In the context of German tenancy law, silence is never consent.
No.
The models point out two distinct failures here. First, an email sent at the close of business on a Friday for a Monday morning appointment fails the legal test for reasonable notice.
Because it's over the weekend.
Exactly. German courts typically require 1 to 2 weeks of advance notice for non-urgent administrative entries.
Wow, 1 to 2 weeks.
Yeah. And second, a landlord cannot unilaterally manufacture consent through ultimatums. The tenant holds the right to quiet enjoyment of the property.
Right.
Affirmative, explicit permission is required for entry. Without it, the use of the key is unequivocally illegal.
Okay, so the tenant is violated, but they possess a clear factual matrix. They have the time-stamped emails. They have the utility worker as a third-party witness to the unauthorized entry.
They have all proof?
Yeah, and they bring these facts to the AI gauntlet. We transition here from the subjective trauma of the event to how the AI architectures categorize the intrusion under the strict definitions of German law.
And all the major models, Gemini, ChatGPT, Claude, they immediately validate the tenant's position.
Yeah, they confirm the landlady's actions were totally illegal, and they cite substantial statutory authority to back it up.
They anchor their analysis in Article 13 of the German Basic Law, the Grundgesetz.
Which is a big deal.
It is a massive deal. This is the constitutional guarantee regarding the inviolability of the home.
Right.
And it is worth noting the historical weight of Article 13. Drafted in the aftermath of World War II, this constitutional protection was a direct response to the arbitrary home invasions conducted by the state apparatus.
Oh, wow. So it has deep historical roots.
Very deep. By citing Article 13, the AIs elevate the landlady's action from a mere lease violation to a breach of a fundamental civil right.
That is a huge escalation in terms of how seriously it's taken.
And they pair this constitutional foundation with Section 535 of the German Civil Code, the BGB, which codifies the landlord's primary obligation to grant the tenant peaceful, undisturbed use of the leased property.
Okay, so the AIs then introduce the criminal dimension of the dispute. They categorize the intrusion as Hausfriedensbruch, which basically translates to trespassing or a breach of domestic peace, falling under Section 123 of the German Criminal Code, the StGB.
Right, so it's an actual crime.
It is a defined criminal offense to unlawfully enter another person's dwelling. Now, if I'm the tenant reading this AI output, My immediate assumption is that I possess the leverage to initiate a criminal prosecution.
Because you have the evidence.
Exactly. I have the constitutional violation, the penal code statute, and the witness. I'm ready to call the police.
But this is where the AI demonstrates its capability as a procedural strategist rather than just a legal encyclopedia.
Okay, what do you mean?
Well, Gemini and ChatGPT 5.5 introduce a structural limitation of the German legal system. They explain that Hausfriedensbruch is classified as an Antragsdelikt.
An Antragsdelikt. What exactly is that?
This is a crucial distinction. In German law, an Antragsdelikt is an offense that requires a formal complaint from the victim to initiate prosecution. Yeah, the state mechanism will not pursue it automatically, the way it would a robbery or an assault.
Right. So the philosophy behind an Antragsdelikt is essentially about judicial resource management and respecting the victim's agency, right?
Exactly.
The state recognizes that a breach of domestic peace, while a crime, is often a private dispute. By requiring the victim to formally request prosecution, the state avoids inserting itself into every minor property conflict, conserving resources for crimes that threaten public safety.
But that philosophical framework creates a procedural trap for the tenant. The AIs point out that because an Antragsdelikt relies on victim initiation, it is subject to a strict statutory limitation.
There's a ticking clock.
A very fast ticking clock. The victim has exactly 3 months from the date of the incident to file the formal complaint.
Oh no, and here we get the reality of the timeline, because the intrusion occurred in May 2023.
Yep.
But the tenant is consulting the AI models in May 2026.
3 years later.
3 years later. So the 3-month window has completely expired. The criminal justice system is entirely inaccessible to the tenant at this point.
It's gone. The crime absolutely occurred, but the procedural mechanism to punish it has totally timed out.
So what does the AI suggest they do? Just give up?
Well, amidst this dense analysis of constitutional rights and expired criminal statutes, Gemini pivots to offer a highly pragmatic, non-legalistic intervention.
Which is?
It advises the tenant to temporarily abandon the legal abstractions, visit a local hardware store, purchase a new door cylinder for 20 or 30 euros, and physically change the lock.
Ah, I love that. It is a brilliant example of functional problem solving over legal maneuvering.
It really is.
Yeah.
The AI notes that German property law allows a tenant to alter the locks to secure their privacy, provided they retain the original cylinder and reinstall it upon terminating the lease.
So you just swap it out and keep the old one in a drawer.
Exactly. It solves the immediate security vulnerability without requiring a court order or months of litigation.
What's fascinating here is how the AI models partition the conflict. They clearly separate the moral victory from the actionable legal victory.
Yeah, they validate that the tenant was criminally wronged and morally justified in their outrage.
Right. Your feelings are valid.
But they relentlessly point out that the legal machine operates on strict procedural deadlines. The criminal route is dead. The tenant must look to civil law for a remedy.
Okay, so since criminal punishment is impossible, the tenant asks the AIs about pursuing civil damages, specifically regarding psychological trauma.
And this gets really intense.
It does. The tenant inputs a sensitive piece of medical data into the prompt. They disclose a formal psychiatric diagnosis of paranoid personality disorder.
Wow.
Yeah, and they explicitly attribute the worsening of this condition to the borderline experience of waking up to the landlady in their bedroom. They ask the models to assess their probability of securing Schmerzensgeld.
Right, and Schmerzensgeld is the German legal mechanism for financial compensation regarding pain and suffering. It includes psychological shock damages under Section 253 of the Civil Code. But the major AI models, Viera, Claude, and ChatGPT 5.2, they deliver a really sobering assessment of how civil courts actually treat psychiatric claims.
Yeah, the AIs highlight what they refer to as the causality problem. In civil litigation, demonstrating that a defendant acted illegally is only half the battle.
It's not enough to just say they did a bad thing.
No. The plaintiff must prove that the illegal act was the direct, proximate cause of the specific damages claimed.
And the models cross-reference the legal standard for causality against the clinical definition of the tenant's diagnosis.
Okay, so they look at what paranoid personality disorder actually is.
Right. A personality disorder, such as paranoid personality disorder, is classified in psychiatric literature as a deeply ingrained structural pattern of thought and behavior.
It's not a temporary thing.
Exactly. It is fundamentally a long-term condition.
Yeah.
It does not spontaneously generate from a single isolated fright on a Monday morning.
So I would assume the landlady's defense counsel would immediately leverage that clinical definition.
Oh, instantly.
They would argue that the tenant's psychological distress is an unfortunate manifestation of a pre-existing psychiatric condition, not a direct product of the meter reading.
Right. They'd say, we didn't cause this. They already had this issue.
And the burden of proof rests entirely on the tenant to dismantle that defense.
And to overcome that defense, the tenant would be forced to secure highly specialized, incredibly expensive psychiatric testimony.
Which takes time and a lot of money.
The expert witness would have to convince a civil judge that this singular intrusion either definitively triggered the disorder, which is a huge clinical hurdle, or that it drastically and quantifiably exacerbated a pre-existing baseline.
And how do the AIs weigh those odds?
The AIs calculate that the financial costs of the medical experts would likely exceed any potential payout, and the evidentiary threshold is just too high to guarantee success.
So it's a massive financial risk.
They project that a court, at best, might award a nominal sum of 200 to 800 euros as symbolic compensation for the sheer annoyance of the privacy breach.
But, and this is where the transcript gets really interesting, there is a significant divergence among the models. One specific AI, Mistral Small, processes the exact same prompt and generates a wildly optimistic response.
Yeah, Mistral Small completely breaks from the consensus.
It validates the paranoid personality disorder diagnosis and confidently asserts that the tenant could secure between 1,000 and 5,000 euros in Schmerzensgeld.
Now, that divergence exposes the underlying mechanics of how large language models actually function and specifically how they can fail.
Right, because why is it so different?
Well, smaller architecture models like Mistral Small operate with fewer parameters and constrained context windows. When this model ingested the prompt, it heavily weighted the specific semantic tokens associated with severe medical terminology words like paranoid personality disorder and trauma.
Okay.
In its training data, severe medical terms frequently correlate with high financial compensation in legal contexts.
So Mistral Small essentially performed a basic word association calculation rather than a complex logical deduction. It saw a serious psychiatric term and just output a large number, completely bypassing the multi-step legal reasoning required to analyze German burden of proof standards.
It generated a response aligned with the user's emotional desire rather than objective legal reality.
That is so dangerous, honestly.
It prioritized user sentiment over rigorous statutory analysis. Claude and ChatGPT, utilizing more robust architectures, suppressed the immediate sentiment-based response and correctly applied the structural constraints of causality law.
I do want to challenge the pragmatic consensus of the larger models, though.
Okay, go for it.
If a tenant genuinely experiences a severe traumatic response, and we have no reason to invalidate their lived experience of having their sanctuary breached, right?
Sure.
Shouldn't the legal system provide an avenue for that emotional reality to be recognized? By advising against the lawsuit, the AIs are essentially telling the tenant to suppress their trauma because it isn't financially efficient to pursue it.
That is a very valid philosophical critique of the justice system, but Claude actually addresses this by explaining the strategic purpose of civil litigation.
What does Claude say?
The law is a mechanism for dispute resolution based on demonstrable facts. It's not a therapeutic space for emotional validation.
That's harsh but true.
If the tenant initiates a trauma lawsuit driven by a desire for emotional recognition, they are exposing themselves to immense financial risk. If they fail to prove causality, which the AI says is highly probable, they will be liable for the court costs and the landlady's legal fees.
Oh, wow. So they could end up paying the person who violated them.
Exactly. The AI is functioning as a fiduciary here, prioritizing the long-term financial and psychological stability of the user over a risky, emotionally driven crusade.
The necessity of that risk-averse advice becomes entirely apparent when we look at the broader context of the tenant's life.
Because there is so much more to this story.
There is. The AIs advise against a standalone trauma lawsuit, but they clearly identify the intrusion as a valuable strategic asset. But to deploy that asset effectively, the AIs must help the tenant navigate a complex web of pre-existing vulnerabilities.
Yeah, the third question in the tenant's prompt introduces an astonishing amount of background conflict. The single intrusion is actually just the latest skirmish in a protracted war of attrition between the tenant and the landlady.
It's messy. The tenant discloses 4 massive complications to the AI gauntlet. First, there is a dormant eviction lawsuit from 2023 that has never been formally resolved.
Which is a huge dark cloud hanging over them.
Huge. Second, there is an extensive ignored list of apartment defects from 2022, primarily centered around mold and structural roof damage.
Classic landlord dispute stuff.
Third, as a response to the mold, the tenant has been paying rent under reservation for 19 consecutive months.
19 months.
Yeah. And finally, due to these financial maneuvers, the tenant is currently remitting only €150 out of a total monthly rent of €960.
The AIs immediately zero in on that phrase, under reservation. This is the primary structural weakness in the tenant's legal position.
So if we look at the under reservation tactic,
Yeah.
paying rent while explicitly stating you might reclaim it later due to defects like mold, it seems like a prudent half measure to a normal person.
It sounds smart.
Right. You avoid immediate default by transferring some funds, but you maintain financial leverage until the landlord initiates repairs.
I'd actually push back on the idea that it maintains leverage in this specific context. While it sounds protective, Claude and ChatGPT 5.4 identify a critical vulnerability there.
What's the vulnerability?
Paying rent under reservation is a declarative statement of dispute. It is not a legally protected rent reduction, which is known in German law as Mietminderung.
And the procedural difference between those two concepts is vast, isn't it?
It is night and day. A lawful Mietminderung requires a strict protocol. You must formally document the defect, notify the landlord in writing, establish a reasonable deadline for repair, and then deduct a specific percentage based on established legal precedents for that particular defect.
Like you can't just guess a number.
No, there are tables for this.
Yeah.
If you bypass that protocol and unilaterally withhold €800 a month under a vague claim of reservation, you are technically accumulating severe rent arrears.
You're just not paying your rent.
Exactly. By doing this for 19 months while a dormant eviction lawsuit already exists, the tenant has essentially handed the landlady the ammunition required to execute a rapid, legally sound eviction.
Wow. So the AIs recognize that the tenant's overall position is highly precarious.
Extreme.
The strategy must shift from punishing the landlady for the intrusion to utilizing the intrusion to neutralize these existential threats. And this introduces the most complex variable in the entire dispute: the job center.
Yes, the job center. This changes everything.
The tenant reveals their ultimate objective. They require the local welfare office, the job center, to assume the full cost of accommodation, referred to as the KDU.
But the German welfare state operates on rigid algorithms.
They don't care about the drama.
Not at all. The state will not disperse funds for a highly disputed, chaotic rental arrangement, particularly if the administrative record suggests the tenant is unlawfully withholding rent.
Right. To unlock the state funding, the tenant must demonstrate to the job center that the living situation is objectively unreasonable or unzumbar, and critically, that the landlady is the instigator of the chaos.
And the AI models synthesize this bureaucratic requirement into a singular, actionable objective. The tenant needs documentary evidence of the landlady's aggression to satisfy the job center's algorithmic requirements.
They need a piece of paper.
Yes. The models propose extracting a formal confession regarding the Monday morning intrusion.
Here's where it gets really interesting. The negotiation shifts away from a simple exchange of financial compensation. The currency of this dispute becomes administrative leverage.
It's all about leverage.
The tenant is deploying artificial intelligence to outmaneuver the landlady in order to satisfy the evidentiary demands of the German welfare state.
It requires the AIs to navigate the friction between three distinct systems: the human emotional desire for retribution, the legal defenses of the landlady's counsel, and the bureaucratic accounting rules of the welfare office.
That is a lot to juggle.
It is. The models begin drafting an out-of-court settlement, and their varying approaches reveal profound insights into negotiation strategy.
The first hurdle is the psychological barrier of the confession itself. If a draft settlement demands that the landlady sign a document stating, "I admit to the criminal offense of Hausfriedensbruch," opposing counsel will instantly reject it.
Oh, absolutely.
You cannot compel a competent lawyer to endorse a penal code violation on behalf of their client. It's just not going to happen.
But Gemini identifies this legal impasse and proposes a solution based entirely on semantic framing.
Okay, how does it frame it?
It advises the tenant to strip the settlement of any legal conclusions or accusatory language. The AI drafts a clause that relies purely on neutral chronological facts.
Oh, I like this.
It reads, "The parties agreed that on May 8th, 2023, the landlady entered the apartment using a key without prior permission to read a meter while the tenant was in bed."
By removing the word illegal or trespassing, The AI neutralizes the threat of criminal liability. The landlady's lawyer can review that text and conclude,
Okay.
we are admitting a sequence of events occurred to resolve a broader dispute, but we are not confessing to a crime.
Right. It's just stating what physically happened.
Yet that precise sequence of neutral facts is mathematically sufficient to prove to the job center that the living situation is unzumutbar.
Exactly.
The AI threads the needle between the opposing counsel's defensive perimeter and the job center's evidentiary requirements.
But the most sophisticated strategic intervention comes from ChatGPT 5.5, which identifies a hidden vulnerability regarding the financial component of the settlement.
Okay, what did it find?
The tenant wants the landlady to pay a sum of money as an apology for the intrusion, but ChatGPT 5.5 analyzes how the job center calculates income.
This is a classic sociological phenomenon known as a welfare trap.
It really is.
The welfare state calculates housing benefits based on actual incurred costs. If the settlement forces the landlady to pay the tenant 500 euros, and that payment is categorized as a rent credit or a retroactive rent reduction, the job center's algorithm will register that the tenant's housing costs have decreased.
Right. They see it as, oh, your rent is cheaper now.
Exactly. So the state will simply reduce the tenant's monthly benefit allocation by 500 euros. The tenant gains absolutely zero net capital. The landlady's apology money is entirely absorbed by the state treasury.
But ChatGPT 5.5 circumvents the welfare trap through precise legal categorization.
How so?
It instructs the tenant that any financial payout must be explicitly designated in the settlement as immaterial damages or Schmerzensgeld for a violation of personal rights.
Because that's treated differently.
Exactly. Under German welfare regulations, compensation awarded for pain and suffering is privileged capital. It cannot be classified as standard income, and therefore it cannot be used to offset housing benefits.
That is brilliant.
The AI ensures the tenant actually captures the financial value of the settlement.
The capacity of the AI to operate simultaneously as a constitutional scholar, a negotiation strategist, and a welfare accounting expert is staggering. It totally understands the interconnected ecosystem of the tenant's legal and financial existence.
And this brings us to the climax of the consultation, where all these theoretical strategies must be compiled into a final document.
Right.
The final AI persona, which was instructed to operate as an expert tenancy lawyer, synthesizes the data and generates a comprehensive settlement proposal.
We can categorize this initial AI draft as a diplomatic peace treaty. It is highly calibrated and objectively fair.
It's a very solid draft.
The AI proposes that the tenant will pay a lump sum of 1,800 euros to resolve the 19 months of legally dubious under-reservation rent arrears. In exchange, the landlady must formally withdraw the 2023 eviction lawsuit, commit to a binding timeline to eradicate the mold by December 2025, and sign the neutrally phrased factual acknowledgement of the intrusion.
If a human attorney drafted this, it would be considered a masterstroke of de-escalation.
Completely.
It acknowledges the tenant's exposure regarding the rent arrears, offering cash to neutralize the eviction threat. It secures the documentary evidence required to unlock the job center funding, and it establishes a mechanism to finally repair the apartment. It is a mutually beneficial off-ramp from years of trench warfare.
But the introduction of the human element disrupts the AI's logical equilibrium.
Because humans are emotional.
Very. The tenant reviews this balanced, slate-cleaning proposal and rejects it. The trauma of the intrusion overrides the pragmatic desire for resolution. The tenant wants to inflict discomfort on the landlady.
They want them to hurt a little bit.
They do, so they input a final prompt into the interface. Deutlich schärfer.
Which means significantly sharper, please.
For 20 minutes, the AI models have functioned as a moderating force. They warned about the burden of proof, counseled against unwinnable lawsuits, and engineered a balanced compromise to satisfy the welfare state.
They were the voice of reason.
But upon receiving that three-word command, the AI instantly abandons its role as a diplomat. It transforms the text into an aggressive legal weapon.
This sequence provides a stark demonstration of AI alignment and subservience. The model possesses no internal moral compass or commitment to de-escalation.
It just does what it's told.
Exactly. It is a tool designed to execute user intent. When commanded to escalate, it optimizes the text for maximum intimidation.
Let's break down the mechanics of the escalation. The preamble of the letter shifts immediately. It is no longer framed as a proposal for amicable settlement.
No, the tone is completely different.
The AI restructures it as a last out-of-court settlement offer, establishing an immediate implicit threat of litigation.
And the AI completely re-engineers the financial dynamics, too. In the diplomatic draft, the €1,800 payment was an acknowledgement of the tenant's vulnerability regarding the rent arrears.
Right.
In the sharpened draft, the AI increases the proposed payment to €2,200, but it weaponizes the capital.
Wait, it offers more money to be more aggressive.
Yes, it frames the payment not as a concession, but as a demonstration of dominance. It asserts that the tenant is operating from a position of clear superiority due to the landlady's unlawful entry.
It leverages the capital to humiliate the opponent.
Precisely.
And then the AI deploys the exact legal threats it previously advised the tenant were practically unwinnable. It explicitly threatens to initiate the lawsuit for Schmerzen's Guild.
Even though it just said that was a bad idea.
Right. It demands a penalty-backed cease and desist declaration, a Strafbewehre Unterlassungserklärung, which would financially penalize the landlady for any future boundary violations. It isolates every legal vulnerability the landlady possesses and presents them in a highly concentrated format.
If we connect this to the bigger picture, we are witnessing the fundamental duality of consumer-facing artificial intelligence.
It's a double-edged sword.
It really is. It has the capacity to act as an extraordinary voice of reason. It educated the user on the nuances of causality, explained the intricacies of constitutional law, and identified complex welfare traps. It mapped out the safest route through a hazardous legal landscape.
But it went from a diplomatic peace treaty to a legal hostage negotiation simply because the user pushed a button.
It is infinitely compliant.
It will draft a threat perfectly calibrated to maximize psychological pressure, entirely indifferent to the real-world consequences. If the landlady's counsel reacts to that sharpened letter by terminating negotiations and accelerating the eviction, the AI experiences zero fallout.
Right, the AI doesn't get evicted.
Exactly. It does not have to face the job center or pack up the apartment.
The entire exercise is an incredibly vivid translation of emotional distress into structural leverage, mediated entirely by algorithms.
We've covered massive ground today. We analyzed a scenario where a tenant utilized a spectrum of AI architectures to navigate a labyrinth of boundary violations, emergency key definitions, constitutional rights, procedural deadlines, and welfare accounting algorithms.
It is a lot to take in.
We watched as raw human trauma was processed through large language models to output a highly sophisticated and ultimately weaponized legal strategy. So what does this all mean for you, the listener?
The primary takeaway is that the barrier to entry for high-level legal analysis has essentially vanished. AI is an unprecedented resource for understanding your statutory rights, formulating strategic options, and generating precise legal documentation.
Levels the playing field.
It does. It can identify structural advantages like the job center income hack that an average citizen would never recognize on their own. However, the abdication of human judgment is not an option.
No, you can't just blindly follow it.
Exactly. The AI will provide the analysis and write the aggressive letter, but the human user retains the exclusive responsibility for the consequences of escalation. The tool is neutral. The application of the tool carries immense risk.
Which leaves us with a final provocative thought to consider as you process this deep dive.
What's that?
We have crossed a threshold where anyone with a smartphone possesses access to a highly competent, infinitely aggressive legal strategist at zero cost.
It's available to everyone.
Are we on the precipice of a massive surge in asymmetrical legal warfare, where everyday people routinely bombard their landlords, employers, and neighbors with perfectly drafted, legally terrifying ultimatums?
That is a scary thought.
Will the democratization of legal knowledge balance the scales of justice, or will the sheer volume of algorithmically generated escalation completely break the underlying systems we rely on to resolve human conflict? The AI can identify the fracture in the law with absolute precision. How we choose to wield that clarity is entirely up to